where do we want to start
Oh
with all
man.
these things? The Unlawful Enclosures Act, or do we want to start with the fact pattern?
I'm going to go based on what I was told to do for the presentation, and I think we should start with, the high level points of Iron Bar.
Okay.
And as you saw in the CLE, that the continuing legal education class that we taught, there is so many different levels to this case and to this issue.
Right. So for those of you wondering, this is the course outline I got, and Dylan did a great job walking through this. And I wrote notes in the corners. I appreciate you guys allowing me to write notes at the bottom.
The only thing I do want to add, and this is just real quick, I just want to say that we partnered with National Wild Turkey Federation for this, and I do want to give them a little bit of credit because they were great partners on this CLE. But it was, like you said, it was a fantastic CLE, and the issues we covered, even though they were legal based, man, were they relevant to hunting and public access, right?
Yeah, very relevant. And so it wasn't just those of us who were in Bozeman at your office.
Yeah.
There was remote. People could join.
Goodness, we had somebody from New Jersey, I believe, which is just incredible. I mean, I really hope the person in New Jersey learned a whole lot about Endangered Species Act and corner crossing because
and federal land disposal.
Exactly. I mean, it must have been. I'm glad we had such a wide range of people to join because I mean, you were there in person, man. We had such a great discussion as well. It was fantastic.
Yeah. So, all these highlight things.
Yeah.
I'm going to let you kind of go through it because I was taking notes, and I'm the conservative accountant. I always am in everything I do take into consideration property rights and private property rights.
Absolutely.
It's foundational to our country. It's foundational to our systems of law, of our economy, and I always work on the side of caution towards that.
Yep.
So,
absolutely. Especially in this sort of sense where not only are you trying to respect your fellow Americans, your fellow private property owners, but a lot of these private property owners are conservationists themselves.
Right.
But on top of all that, hunting, and I mean, as much as I wish we had a United States constitutional mandate, hunting is a privilege.
Right.
And we got to treat our private property owner partners when we're using this privilege. So it's something that you really should take into account whenever you're doing any sort of thing like this, which is, I don't want to say infringing on private property rights, but again, according to the 10th Circuit and Wyoming law, you are infringing on private property rights. It is just that it is not against the statute.
Right. So, walk us through these important facts, and I'll try not to interrupt, but I know I'm going to have to interject and ask more questions, Dylan.
You absolutely should. I'm going to do my best to give the 1% of attorneys a good name and not be part of the other 99%. And please interject because I dang sure can get in the weeds pretty easily. So what's really important to remember here is the fact pattern. Right. The fact pattern here is you had hunters, and to be very clear, they corner crossed twice, right? They corner crossed in 2020 and then corner crossed in 2021. However, the 2020 fact pattern wasn't in play. And that's when they touched the fence, which, as many people might understand, that might seem very minimal, but touching the fence actually creates a totally different fact pattern, right? Because you're touching private property. Yeah. So the fact pattern here, like you really, really well said, is they were on BLM land. They knew where the corner was because it was marked with a survey marker and 2 fence posts with a sign saying no trespassing. They put a step ladder over the fence, and without touching the fence or private land, because they knew exactly where it was, they crossed over to BLM. Right. And they did that several times. Yeah. And in doing so, never touched private land. They knew exactly where the public land was. And again, this public land is totally inaccessible in any other way. It is completely locked off. Do you think your audience is familiar enough with with checkerboard?
Yeah.
Okay, perfect. Yeah. Because that is another thing that is really important here is that this is specifically checkerboard. And the reason,
and I want people. Let me make sure that I want to back up there. Mm-hmm. A lot of people think that anytime 2 corners touch, that's checkerboard.
No. Yeah.
This was one of the railroad land grants that created checkerboard. If you look at I-80 going across southern Wyoming, and then where I-80 continues across Utah, to a lesser degree, they through trades or otherwise, they've lessened some of that in Utah.
Yeah.
You get back in Nevada, and where I-80 goes,
Yep.
it's all checkerboard again.
Yeah, absolutely.
So the court, in the opinion, if I understood it correctly, made quite a distinction about this being the checkerboard.
So this is where we have to be real careful, because the district court was super narrow. It laid out all the facts in this case so exactly, saying that like this is the fact pattern where the Unlawful Enclosures Act preempts or overrules state law.
Right.
And to be completely honest, the 10th Circuit wasn't as narrow or as careful. It brings up the checkerboard. It talks about all the facts that we're talking about, but it didn't rely on it as heavily as a district court. But again, for your listeners, and if you really want to follow what is totally held under this case, it is best to do what the district court said, which is follow it almost to a T.
Right.
Yep.
Okay. So these guys went through great pains. These 4 Missouri hunters, what they went through and the steps they took to make sure they did not touch private land is significant.
Absolutely.
It wasn't, oh, this is close enough, or, oh, we'll climb over. He's got a gate here. Let's say it's easier to climb over the gate than to climb over the 4 strands.
Yep.
No, they carried a ladder. So
yeah, exactly. They may, again, like I said, in the 2020 situation, which was a little bit different, but in 2021, they took great pains not to touch any sort of private property or private land. And that is, again, since that is mentioned in the case, that is central to the holding, whether or not it is, again, district court took great pains to lay it out where the 10th Circuit did not take as many steps to do so. Yeah. So they did that. And again, I think you laid out pretty well what happened to the hunters after that, getting charged criminally and then getting sued civilly. And then going into what the 10th Circuit said. Again, I'm going to keep saying this just so everyone knows. The 10th Circuit held that in Wyoming, corner crossing and crossing private airspace or the airspace over private property is trespass under civil law.
Civil trespass.
Civil trespass, exactly. And what they said, again, is that civil trespass is preempted by what's called the Unlawful Enclosures Act. And to give now I think we do need to get into the history of this thing, right? The Unlawful Enclosures Act is an act that was passed in the 1800s, and it basically was passed because of this checkerboard and the railroad grants that we were talking about. You had people that were successors that owned the railroad grants that were blocking off public land, either fencing off water sources, because we're talking about the Western United States where, man, there's just not a lot of rain, right? Really arid, blocking off the water sources, blocking off public access to the grazing, and blocking off, homesteaders and mineral development. So Congress came in and said, you can't block this stuff. And basically said, we're not going to allow you to fence off public parcels. Again, we can, as Randy saw, us lawyers can talk about these cases from the late 1800s and early 1900s and range wars and sheep herders and cattle drivers. But I'm going to save your audience the pain of getting into the legal details. But basically, the most important thing to know is these early cases all dealt with what's called range wars. So you had different livestock producers and grazers fighting each other, sometimes physically, sometimes legally, a lot of times both, preventing access to public lands. And basically, in all of those cases, there's cases in the Supreme Court and there's cases from the circuit courts basically said you cannot fence off or prevent access to public lands. And then we get to Leo Sheep, which is a really interesting case, I believe, from the 1970s, that had to do, again, with Wyoming. As you guys are going to probably notice if you dig into this, Wyoming is the epicenter of corner crossing, checkerboard, and all this sort of
Leo Sheep case is, if I remember right, is in the same county as what the Iron Bar
I think
case
it is, but it's north of I-80.
It's north of I-80 instead of south.
Exactly. But yeah, that is,
I think they're all in Carbon County.
Yeah. only know Carbon County because the unit that the Leo Sheep case takes place in, right?
Yeah.
So Leo Sheep basically said, and again, we're going to paraphrase here, what the government wanted to do is you have this publicly owned reservoir and publicly owned land on the north side of the reservoir. So you can access the reservoir from the north side, and you had public land. And the federal government said, well, because it's Unlawful Enclosure Act, what's stopping us from building a road on the corners to the reservoir and to this public land? I mean, we're going to be crossing private land, but the Unlawful Enclosure Act lets us do this. And the Supreme Court basically said two things. One, because the federal government can take land by what's called eminent domain.
Right.
And basically eminent domain is when the government goes through a process to take somebody's land but pay them fair value for their land. The government can't do what's called a easement by necessity, or which is again, we're trying to stay away from all the legal details here, but an easement by necessity is exactly what it sounds like. It's when you need an easement to reach your land by necessity.
Right.
But because the government can take land by eminent domain, there's no necessity to do that.
Right.
And on top of that, again, this reservoir and land was accessible from the north. So the Supreme Court said, you can't do this. This is not an Unlawful Enclosures Act case because you're not trying to get public access. You're building a road. Yeah. And you're building a road across private land, and that's a taking under the federal Constitution. So, and then the Supreme Court in that case also distinguished all those older cases we were talking about the range wars, and basically said three things that distinguished them. One, a lot of those cases dealt with open range, which I'm not an expert in open range, but basically open range is a old common law that had to deal with grazing. Then second, you were dealing with you're dealing with the fact patterns of the day, which is you're having grazers trying to access public land for grazing. You're not building a road. You're not dealing with any of that sort of thing. And third, you weren't dealing with an area that had public access. The reservoir
was no other way.
Exactly. The reservoir was accessible from the north. And all this in that case is what we call dicta. And the best way to describe dicta is stuff that is not central to the holding in the case. So basically no one knows whether it's actually the holding or whether it's just the Supreme Court getting on their soapbox, which is really interesting. And yeah.
You mean they actually do that?
Oh,
get on their soapbox.
Oh, man. It's kind of funny. If you're not a lawyer, you'll never kind of see judges getting on their soapbox. But especially in the recent past, as long as I've been a lawyer, man, there's a lot of judges getting on their soapbox, and it's pretty entertaining if you know what to look for. It's entertaining for legal nerds, put it that way. So that was Leo Sheep. And then we have a 10th Circuit case that came out in the 1980s, I believe, either late 1970s or the 1980s, called Bergen versus Lawrence. And this dealt, interestingly enough, with a landowner who was found to be blocking access to Pronghorn to the Red Desert. Yep. And again, maybe Carbon County, but it also might be the county just west of it.
It's either Carbon or Sweetwater.
Exactly. Yeah. Yep. So basically in that case, the 10th Circuit said, okay, Leo Sheep makes total sense, but it only applies to building roads and taking land. Here, what we have, a landowner fenced off access to wildlife to public land.
Right.
Totally different case, according to the 10th Circuit. And in that case, the 10th Circuit said Leo Sheep doesn't apply here because we don't have a taking. We don't have the government trying to build a road on private land. Instead, we have wildlife trying to access public land. And this is what gets really interesting in courts and cases. In that case, the district court made a finding of fact. So when we talked about facts and law, in this case, the district court actually found, as a matter of fact, that the antelope pronghorn could not reasonably access to public land. And the appellate court said because of that factual finding, that the pronghorn couldn't access the public land, that fence had to be either replaced with BLM wildlife-friendly fencing or taken down completely. Yeah. And basically what it did, what us lawyers call distinguished Leo Sheep, which says that Leo Sheep is still good law, it's binding on us, but it doesn't apply in this case. Okay. And that's what's actually really interesting about Iron Bar. Iron Bar said the same thing. Said that
Leo Sheep does not apply. This isn't the BLM or the federal government trying to build a road across Iron Bar.
Yep. Exactly. But to also be very clear, we all have to understand that Iron Bar is going to argue the exact opposite.
Right.
And that's what they're going to argue in front of the Supreme Court, which is like, look at this Western Circuit Court just ignoring your case law. And you could see that from their original filing. That is going to be their main argument, is that you have this 10th Circuit basically saying that the Supreme Court, you have this case, Leo Sheep. They've distinguished it to the point where it really doesn't even apply to any of these cases. Please rehear this case. So, yeah, you're exactly right there.
Okay. So that case, Bergen got decided in favor of the pronghorn, I'm going to say.
Exactly. In favor of the federal government suing for the pronghorn, which is pretty funny.
Yeah. And if I remember right, that landowner I think he sold some of that property and it's now a wildlife management area. If I remember right, it's a Red Rim Daily wildlife management area in Wyoming, or part of his property.
Absolutely makes sense.
Where there's no fences and the pronghorn can just go from private to public because they do migrate.
Oh, yeah. I mean, it's amazing. People don't realize how, that's one of the largest, isn't that one of the longest migrations in North America or something like that? It's a crazy migration.
Yeah. So that case then became something that, how did that impact Iron Bar then?
Yeah, so that is the primary case that the Iron Bar court relied on.
Okay.
Because the way that these appellate courts work is any prior case in the same circuit binds future circuits, binds future courts in that circuit, future cases. So because that case came before Iron Bar, it binded the Iron Bar court. And again, basically, there's
exceptions to every rule.
The exceptions is what's called en banc, is when the full court hears a case and then they can overrule prior circuit precedent. Yep, which did not happen here.
Okay. So the important part there is the fact pattern that got us here. These guys did an amazing job. The fact that this wasn't the federal government coming to a landowner and saying, "Oh, we're going to build a road across your corner."
Yep.
This was some private parties doing everything they possibly could to not touch the private ground and did not do so.
Yep.
And overcame the obstacles intended to keep the public off the public land.
Exactly. And that is what they said at Iron Bar, right? Is that because there was an effective barrier to the public land. Because again, to remind everyone in this case, there weren't like all these fences around the public land. It wasn't like there was this physical barrier, right? There was this legal barrier. And what the 10th Circuit said in Iron Bar is that a legal barrier to the public land is still a barrier that cannot be used under the Unlawful Enclosures Act.
Yeah. So Unlawful Enclosures Act is deemed to preempt the finding that under Wyoming law, this was civil trespass.
Yes, exactly. And again, that's the really interesting part to like really hammer home is it was held as civil trespass by the 10th Circuit. So the Wyoming courts or the legislature can always come in and change that. They're just unlikely to do so. So that's the kind of interesting wrinkle here is Wyoming's never actually had the final say on what is civil trespass regarding crossing the airspace or corner crossing in Wyoming. Right. The 10th Circuit made that decision.
Okay. So for a lot of people who are trying to figure out this airspace thing and they're trying to extrapolate it and apply it to different fact patterns, because that's the thing that interests me, is how many people have got a hold of me and said, "Oh man, I'm going corner crossing."
Yeah.
I'm like, okay, how are your facts? Are they going to be, are you going, and so maybe we get into some of these hypotheticals and I'm not asking you for an opinion. I'm asking for your thoughts about, will a court look at it differently because of these different facts? So,
I mean, like what we like to say in the legal field is different facts and different cases result in different law and different holdings, right?
Right.
So like what you just said is spot on. You know, everyone that ever does this is going to have different facts. The question is, how close are your facts?
Right.
And there is one really important thing that I want to mention about the Unlawful Enclosures Act.
Sure.
The Unlawful Enclosures Act only operates as a defense for the public.
Okay.
The private, the federal government can use the Unlawful Enclosures Act like it did in Bergen versus Lawrence to force a landowner to allow access. But as a private party, we're only allowed to use it once we're either charged criminally or sued.
Yeah.
So that's something that's really important to remember is this is kind of all at your own risk. Even if the 10th Circuit said this, the only time you're going to be able to use this is when you are actually already in court.
Right.
So that's just something, again, I don't want to be this, like you said, CPA being real conservative, a lawyer and an engineer, also very conservative. Don't want to be throwing water on all of this, but it is really important to note that that's how this is going to go if you're going to use this, is you're going to be sued.
Yeah.
And in the 10th Circuit, you have a lot of good law on your side in this very specific circumstance, but you're still going to be in court.
Right.
Yep.
So, knowing that you might be in court, some people would be like, hell with it. I'm pack a lunch. I'll see you in court.
I hope they have a good friend who's a lawyer then, because I think thankfully I'm not in private practice, but I do know those charges aren't cheap unless you're getting a lot of donations. So,
right.
I wish them all the best, frankly.
And this legal defense allowed the 400s to get excellent legal counsel.
Oh, absolutely.
Through a GoFundMe action.
Yeah, they had a lot of support, which is, and again, there's nothing wrong with that. They deserved it.
Yeah. So, some of the things that I know people are contemplating are outside of the 10th Circuit.
Absolutely.
And you clerked in the 9th, which we're sitting in the 9th
we
here
are.
in Montana.
And I believe, as a whole, you have it in front of you, actually. I think the 9th Circuit actually has more checkerboard than the 10th Circuit as a whole.
Yeah. There's a lot.
There's millions of it. Exactly. So you're exactly right that the 9th Circuit looks like you could be kind of salivating at the mouth. Oh, I can start doing this in Arizona and Nevada.
Right.
But really,
the landlocked acres in the 9th Circuit are significantly more than they are in the 10th Circuit.
Exactly.
Wyoming is the largest of any state.
Yeah.
But its surrounding states of Colorado, Utah, they don't have a lot.
No.
They have some, but not a lot. Montana has 870,000.
Yeah.
Oregon, 470,000. Nevada, almost 2 million.
Yeah.
Arizona, 1.3 million. So total acreage, yes.
Absolutely. And that kind of also makes sense if you think about the 9th Circuit. The 9th Circuit is the largest circuit in the United States, both by landmass and population.
Right.
But
of all states, Wyoming does have the most
absolutely
landlocked, corner locked, I would call it.
Yeah,
acres.
because again, the map you're looking at is, I don't think that's actual corner. It's not checkerboard, right? It's just
any place two corners hit.
Yeah.
Right.
Which that's what we're talking about.
Right.
If you really want to push your luck, it's a different ball game when you start trying to corner cross land that isn't checkerboard and not railroad grant checkerboard.
So a lot of people say, well, how did something end up being two corners touching that's not checkerboard?
Yeah.
Well, it easily could have been due to another land exchange.
Yep.
It could have been due to the federal government purchasing land subsequent to the railroad land grants. A common one in Montana is homesteaders
Exactly.
came and they ended up with a 320 or 640, which, a square mile is 640 acres. They couldn't make a go of it, but their neighbor could.
Exactly. Yeah.
Or you have three neighbors who couldn't and three neighbors who could. So now you have the corners touching, because when the three who couldn't, their land got foreclosed on and brought back
Exactly.
to the federal government. And if you look under the old surface maps, it called it Bankhead-Jones Act lands. Well, they're owned by the federal government, but they aren't per se checkerboard.
No. And the other